Hello, hello, hello.
And welcome to the Hildebrand Law Firm topic for today.
I'm Kirsten Hildebrand,
And I'm Matt Kaplan.
and today we're going to discuss sort of an interesting issue, and that is how do you know who to choose to be in these all important positions of personal representative? That is somebody who is going to lead the charge in effectuating the terms of your last will and testament, or trustee, and that is someone who is going to implement what it is that you wanted in your trust provisions. Power of attorney for finances, that's somebody who is working for you while you are alive and maybe unable to manage your financial situation and makes decisions for you. And then finally, power of attorney for healthcare. And the items there are helping to make last healthcare decisions, or healthcare decisions when you're not able to make those. So those are four very important roles, and it should not be identified lightly who should be in those positions. So I think at the outset, we just need to say it is not a good idea to have a power of attorney who is related to financial matters, or rather, a trustee or a personal representative who has some sort of criminal or civil history of stealing money or
Yes.
stealing things, right? Somebody who has had sticky fingers in the past is not necessarily somebody that you would want to put in that position.
I would agree with that.
I
Yeah.
also think, yeah, I also think that as much as we would like to believe that people get past certain behaviors, if somebody is exhibiting behaviors that's not conducive to taking on that responsibility, um, even if it was some time ago, you would really need to think long and hard about whether those behaviors are going to come up again within this context. So, an example would be somebody was a compulsive gambler, and let's say they have been sober for several years, but think again about having them be in those positions, because if they have money available to them, they very well might slip back. It might not be a good idea to put them in that position.
Because and the main thing is that when you're appointing someone as trustee, as personal representative, as power of attorney for either healthcare or finances, but especially finances, you're essentially giving them the keys to the castle.
Mm-hmm.
And yes, you have a rule book in place and the law is in place, but they have unfettered access to all of your stuff. We can certainly come after them after the case if they steal anything, if they do anything that they're not supposed to. But the chances of getting all that money back, especially if someone's a thief, no, they probably already spent it. That's why this document is called a trust. Long story short, you have to put someone in there that you trust. And who are the people that most people trust the most? Their spouse, their children, someone within the family. So whenever anyone asks us, who should we put as successor trustee? My go-to is usually, do you have kids that are old enough, that are mature enough, and that you trust? Thankfully, I'd say 7, 8 times out of 10, they say yes. Would you agree?
Yes, yes, I would. And then the rest of the time is usually trusted nieces and nephews, sometimes grandchildren.
Yeah.
Sometimes the grandparents say, "Well, we don't trust any of our kids 100%, but we do trust that grandchild over there." So there are some interesting ways of approaching the issue, because it's not only trusting that individual, but also believing that they can handle the stress of what might be some interesting family dynamics that will occur during the course of the transition of funds.
So yeah, if you come to us and you say, "Hey, I'm thinking about, my wife and I being initial trustees, and then I want my son to be backup, and then my daughter to do it if he can't do it." Matt, what do you think about that? 2 thumbs up.
Yes.
I think that's a wonderful idea. Now, where things get a little complicated I don't have anybody I trust in my family. I only trust my spouse, and I don't have kids, or I do have kids and I don't trust them. I don't have any siblings that are still alive. What do I do? And what's the answer, Kirsten?
Well, the answer is that you then start to look at third parties. And what can third parties be? It can be friends, it can be maybe distant relatives, it certainly can be a trust company, or it can also be a law firm. We do trust administration here at Hildebrand Law Firm. We also do the functions on behalf of a personal representative. So you could or a agent of power of attorney. So you could say, I want, and then you can name the law firm, or you could name an attorney at the law firm, or you could name you an individual that you hopefully trust, but you would like them to work as a joint or co-agent with the law firm or with another third party, such as a trust company. And also, another way that we can approach it sometimes is we can say, well, we don't necessarily trust this one individual, whether it be a child or a niece or a nephew. Um, I'll take the example of a child. We don't trust this child 100%, but if both of our children are co agents and co personal representatives and co trustees, then we know that they're going to keep each other honest and there'll be two sets of eyes on everything. Now, there are definitely some pros and cons to that, which we have will address in a different session. But in order to just handle that issue of making sure that it's a method that you trust will be reliable, that is another decent approach to handling that.
And another really interesting point is that I get a lot of clients that'll have two or three or four kids, and they say, well, I want everybody to be involved. So I'm going to have kid number one be the trustee, kid number two be the healthcare power of attorney, kid number three be the financial power of attorney, and different combos and all the like. What Matt? What do you think about that? My response is it's not a party. You don't need to have everybody involved. Really, being asked to be a trustee or a power of attorney, it is a difficult responsibility, but a responsibility nonetheless. I always equate it to being asked to be a groomsman or a bridesmaid at a wedding. If anyone's ever been asked to be a groomsman at a wedding, it's a really lovely responsibility, but really it kind of sucks. You have to, you have to buy a suit that you're probably not going to wear ever again, especially for bridesmaids. You have to buy the ugliest dress that doesn't fit any of them well. You have to spend $200 to look like crap. Then you have to show up early. You have to help out with everything. Spend money on nails, hair, makeup. You have to, you're
Have
kind
you
of
gone through this? I mean, this
no,
sounds
but
very personal.
but my wife has, and she didn't like it.
Is that right? So
but
she filled you
so
in.
but like being up there is an amazing responsibility, and you're up there
Yes.
with your friend or your sibling. However, all of it that went into it, it's a responsibility, but it's a hassle. And so, going back to that example, I'd rather be a guest if I could. And so, if you think about, I want to include all my kids, just think about the groomsmen. They'd probably rather be a guest. I'm sure, my philosophy is pick one kid who you like, who you trust the most. As long as you trust them, appoint them for everything as number one. Your other kids won't be upset. They'll be like, oh, wait, so I'm still getting my half and I don't have to do any of the work? Pretty ideal.
Right. That's a very good point.
Yeah.
That is an excellent point. Let's talk for a minute about that power of attorney for healthcare, because
Sure.
that's a little bit of a different category. When you have a healthcare power of attorney and you have somebody who has some medical experience in the family, that's always something that I think is a good indication of who should be in that place. We certainly have had people who have come in who have said, well, I know for sure that our daughter Jane could never do this because she will just be overly emotional about it and she won't be willing to do what I'm asking, which is let me go. And so, in that instance, it makes all the sense in the world to appoint somebody who is going to potentially have a more professional approach towards it. They've seen this sort of thing before, they're familiar with the life cycle It's not going to be as jolting to them as perhaps those of us who don't deal with health issues on a daily basis. So a lot of times people put that individual in place. Also, there's an issue of the language. When speaking with a doctor, they do try to put it into terms that are understandable. But if you have that medical background and you have familiarity, then it just makes it that much easier to communicate with the medical professionals that are trying to advise as to what decisions should be made at particular points in time. So I do always encourage people, if even if it's child number 7 or 8 or whoever it is in the lineup, that they are given that opportunity if the parents think that is a good way to go. Otherwise, I don't know. I think it's just basically whoever is going to be the most attentive. Sometimes the issue of proximity really comes into play, not only with the healthcare power of attorney, but also with the financial power of attorney. Because if somebody's living in California and now all of a sudden they have to start making medical decisions, or they have to start paying checks, writing checks out for bills, that can be a little bit difficult, right? Mm-hmm. And so while there's no prohibition in the law or anywhere else to name out of state children to be your agents, there is a practical implication. And so a lot of times people will pick the in-town kid to make these decisions just because it's going to be a little bit easier. And if there's an emergency, reaction time can be a little bit quicker.
I like that. And one final point about the healthcare power of attorney is all of the other roles, like Kirsten mentioned earlier, if you're uncertain, you can have your kids be co in those roles. With the healthcare power of attorney, that's the one exception that I generally try to steer clients away from having co-agents, because the last thing I would want is for a healthcare action or decision needing to be made, and you have co-agents, you find one of them, but the other one is missing in action.
That's a very good point.
That would freak me out. Especially I've had clients that I want all 3 of my kids to be co-agents. I say, not doing it.
They can consult with each other.
For sure.
And there's no issue with that. But you know, in terms of like signing or conveying the actual decision, that's where it seems like it is advisable to have one, sort of the point of the spear, if you will.
Yeah, and I love writing language that consult with your siblings before
Yes.
making any major medical decisions.
And again, all of these things are very specific to you. So if you came in and you said, but we really, really, really want our 5 kids to be co-healthcare power of attorney, we would absolutely do it, because there's nothing wrong with that per se, but we would certainly advise that you consider what the complications may be. And if at the end of it you still say, nope, this is what we've always planned for, then that's exactly what we end up doing.
Yeah, there's people out there that like funky stuff.
Yeah.
There's Bears fans in the world.
That's right. Not in this room. Not in this firm. All right. Well, thank you so much for joining us. And we are here for your today and your tomorrow. And we will look forward to having you join us next time.